Welcome back to the Tahoe Real Estate Show. We've got a new guest in the studios from Porter Simon Law Firms, Raven. Raven, welcome to the show.
Thank you.
Some of our viewers that maybe aren't familiar with you or Porter Simon Law Firm, give us an overview about the company.
Yeah, so my name is Raven Whittington. I'm an associate attorney at Porter Simon Law Firm. It is a firm that has 3 offices in Reno, Truckee, and Tahoe City. Been around for 40 years in the Tahoe area, and there's 9 lawyers that focus in different practice areas ranging from real estate to personal injury to trust and estates to criminal defense. A broad spectrum, and each of the lawyers focuses sort of on their own practice. My practice in particular is the trial practice group, and there's 3 other attorneys in that. And I deal with disputes when they're going towards litigation in the courts or are already in the courts.
What are some of the legal aspects that are important within real estate transactions?
There are many issues important in an actual real estate transaction, but for the purpose of this discussion today, talking about contracts for either the purchase and sale of property or the leasing of property. And some of the key issues that we see are, one, the terms that go into the contracts themselves. These terms can be negotiated. Also, in a purchase and sale agreement, one of the things we see very often is the seller's obligation to make material disclosures. So to provide information about the house or the commercial building that they're selling that is material to the sale itself. Then from the buyer's side of things, the buyer has a duty of due diligence to look into the property that they're purchasing and find out what sort of defects may be there, what sort of easement issues there may be, zoning issues, leases that may encumber the property. And to circle back, the contracts for the purchase and sale or the leasing of real estate oftentimes have mediation and arbitration clauses in them. And those clauses are very important on the outcome of any potential litigation that may be faced by a dispute down the road. And so I was here to talk today a little bit about the differences between mediation and arbitration and why each is important.
What if there is a dispute? Where do you start?
A dispute hopefully will start with the 2 parties coming together and trying to informally resolve the problem. That oftentimes, unfortunately, doesn't resolve the issue, and so the parties will resort to litigation. And the way that they will proceed with the dispute is governed by the terms of the contract, and that's why it's very important to understand what is in your contract. For instance, if there is a mediation clause in a real estate contract, which is pretty standard in both Nevada and California form real estate contracts, then the parties are obligated to mediate with one another. And mediation is the parties get together and there is a neutral mediator. And the mediator can be a judge or an attorney, and the goal of the mediator is to find the common ground that the 2 parties can settle upon.
Raven, I appreciate you taking the time to come in. I've actually learned a lot about the process. I've been involved in the real estate industry for a number of years, and it's kind of an eye-opener.
Okay, thank you for your time.
All right, stay tuned. The Tahoe Daily Grind is coming up next.